And the teacher is not recognized because of designation, because of the post held by the person, but the person is recognized because of his passion, because of his contribution, and because of his, I think, quality research.
Yes,
other things are secondary.
Certainly, sir. Certainly.
Vijay,
Over to you, Vijay.
Take it
Yes,
over,
sir.
sir.
Yeah.
Vijay, sir.
Ivana?
Thank you.
Shall I start, madam?
Yes, sir.
Yes. Good evening, everyone. Respected resource person of the day, Professor Jeet Singh Man, our beloved principal, sir, Dr. K.B. Kempegoda, sir, my esteemed colleagues and dear participants. I am Dr. Vijay A.N., Assistant Professor and Coordinator of the present FDP program, Vivekananda College of Law, Bangalore. It is my absolute privilege to welcome you all to the inauguration of 7-day faculty development program on new labor codes. Before welcome the gathering, I would like to give brief introduction about our institution and the faculty development program. Janata Education Society, JES, was registered in the year 1972. JES was established with the motto of providing quality education for students belonging to the rural and weaker sections of the society at an affordable cost. JES is a voluntary organization with all the members participating with zeal in rendering free service to the general public. A student aid fund of rupees 2.8 crore has been instituted by Janata Education Society. The interest earned from the corpus fund is being distributed as scholarship to the students who are meritorious as well as economically weaker sections of the society in the JES run institution. It is a matter of pride that JES celebrated its golden jubilee in the year 2022. So Vivekananda College of Law, Bangalore is accredited with B++ grade by NAC, run by Janata Education Society, is recognized by Bar Council of India, New Delhi, and now affiliated to the Karnataka State Law University, Hubballi. VCL was started under the Bangalore University, then in the year 1983 to 84, with 3-year LLB program. 5-year BLLB program was introduced by the Bangalore University in the year 86 and 87, and the same was introduced in our institution in the same year. 5-year BCom LLB program was started in our institution in the academic year 2018 and 19. It is a matter of a great pride to state that this is the 4th decade of imparting legal education. Our institution has a rich tradition of conducting a plethora of academic activities. In our institution, it is an established norms to conclude every semester by conducting an academic exercise such as faculty development program, conferences, national seminar, workshop. Presently, 774 students are studying in our institution. The faculty development program on labor law is crucial as it equips educators and trainers with the knowledge and skill necessary to effectively teach and disseminate information about labor laws and regulations. By enhancing their understanding of the complexities of labor codes, faculty members can better prepare students and professionals to navigate the legal framework governing employment, ensuring compliance, and promoting fair workplace practices. This in turn fosters a more informed workforce, encourages responsible business conduct, and contributes to the development of a just, fair, and equitable labor market. Through such program, participants gain valuable insights into recent legislative reforms, enabling them to address contemporary labor issues with greater competence and confidence. With this brief introduction about the institution and faculty development program, may I now request our beloved principal, Dr. K.P. Kempegoda, sir, to formally welcome the gathering and introduce the resource person. Thank you, sir.
Thank you, Vijay, for your brief introduction about the institution. The respected resource person, an expert on labor law, Professor Jeet Singh Man, sir, and all my colleagues from various law schools, friends. The Janata Education Society's Vivekananda College of Law is organizing every academic year faculty development program. This is the 10th faculty development program in a series. This faculty development program is focuses on the newly introduced the code, the labor code. We have 7-day program schedule, which has already been circulated to the participants here, those who have registered. Total 98 participants have registered, out of whom the people of the professors from Delhi, Andaman Nicobar, Tamil Nadu, Kerala, Odisha, and Calcutta. Friends, I really extremely happy to welcome all of you. I also thank each one of you for your continued support from past 10 years in organizing these programs. Today we have amidst us an expert in labor law, particularly Professor Dr. Jeet Singh Man, a teacher of legal education and research and director, Center for Transparency and Accountability in Governance.
Goda, sir.
Let
us skip that. Let us skip that. That is not so important.
Just
right.
a minute.
Thank you, sir.
Sir, 2 minutes. Sir is a professor at National University, Delhi. And sir's areas of interest is employment law, labor and service law, legal education and empirical research, administrative law. And what impresses me a lot is he has filed several public interest litigation. He is as an activist, and this he fought cases to bring in good governance in the country, for which 6 of his cases have been reported, decided by the Supreme Court and reported. And he has received major projects from various organizations. He is a visiting professor to several universities across the globe. His research publications are more than 100 in national and international level. And sir has readily agreed to be the resource person today to deliver lecture on the topic Applied Labor Law Education Policy and Research. Sir, I, on behalf of Janata Education Society's Vivekananda College of Law and all the participating friends here, a warm welcome to you on this occasion, sir.
Thank you, sir. Thank you.
As I
Thank you very much.
Requested you, since it is the first day FDP program, please inaugurate this session and spend few minutes on the importance of these FDPs for teachers, and then you can switch over to your topic later. With this, I welcome each one of you for this 7-day faculty development program. Thank you. Thank you, one and all.
Thank you, sir. Okay, right, sir. Thank you. Very good evening, friends. I'm JS Man. I'm a teacher and rather student of labor law, because learning is a continuous process, right? A teacher is always a student. We learn from students. We learn from each and every person. We learn from each and every activity. So therefore, I cannot claim any copyright over labor law, right, for having taught the subject for more than 25 years, 30 years. That is, I think, not the requirement. So I believe that a right teacher, right, a good human being can only become a good teacher, right? Teaching is a passion, not employment opportunity. And we require, I think, some kind of training, some kind of, I think, capacity development programs to really inculcate those skills. So we have to really imbibe the culture of quality teaching, quality research. So therefore, it becomes very, very important to organize such programs to overcome certain misconceptions, right? There are certain misconceptions which have been created by the existing literature, where there's a misconception regarding contract of employment or contract of service and contract for service. There are certain misconceptions regarding the recent labor law reforms introduced by the government, right? So we must be well informed. So therefore, it becomes very, very important to organize such programs. So in order to sensitize these stakeholders, labor law teachers, right? And teaching labor law, I think, must be a part of the passion to teach, passion to conduct research, right? And labor law, friends, is a multidisciplinary, I think, subject. It involves several dimensions. It is not confined to only legal dimensions, right? So therefore, it is very, very pertinent to discuss labor law from different perspective based on perceptions, like labor law from the perspective of a UG student is very different from a PG student and PhD student. Same is the case of they see the perception of labor law enforcement agencies like labor law commissioners, provident fund commissioners, ESI directors or commissioners, right? So their perception of labor law is very different from, I think, our perception. So therefore, when it comes to adjudication, right? Adjudication of labor disputes, adjudication of disputes arising out of provident fund scheme, ESI scheme, employees compensation scheme, etc., etc. So therefore, we have to really understand several dimensions of labor law, like administrative law is very important to teach labor law, right? Economical dimensions, I'm talking about labor, that labor economics. That is, I think, the most important component of labor law reforms. We examine labor law from the perspective of cost-benefit analysis, right? We require labor law to be liberalized in order to facilitate the production relationship or production of goods and services. Whether that is going to really promote sustainable development, again, a matter of deliberation and discussion by all the stakeholders. And I believe again that a good human being can become a good professional. So therefore, I believe three important values are important for any professional, right? And I always practice these four fundamentals of life, right? Number one, that hard work is the key to grow to success, right? Hard work is the key to success, right? And therefore, hard work is always recognized. So don't believe in shortcuts. Shortcuts are so short-term benefits, right? So therefore, hard work is the key for a teacher to conduct research or to teach a particular subject with integrated approach. So hard work is the key. Number one. Number two, use your discretion. Use your discretion to teach labor law or any other subject. Don't simply borrow it from others. Like, see, we borrow statements from a particular judgment. We borrow statements of some, learned speakers, right? Or we go by some articles written by somebody. So therefore, a good teacher is required to have independent opinion. Independent opinion based on, I think, reasonable facts, verified facts, undisputed facts, logical conclusion. So therefore, don't simply borrow, I think, some decision, some facts, or maybe some analysis from anybody without analyzing that. So therefore, a researcher or teacher is required to have independent opinion, because we require independent and competent professionals who can excel anywhere in the world. If you are well versed with the fundamentals of labor law, I think you can teach labor law in any country, right? UK, US, or maybe France, Germany, China, or any country, India also. So therefore, that independent opinion is very, very important in case of quality teaching as well as quality research. Now, the third one is that, see, we can grow, we can progress at our own, by our own efforts, but we can never progress by pulling down somebody or at the cost of somebody. That is, I think, this is very, very important for a quality professional, right? So don't try to pull down somebody, right? You must be recognized because of your contribution, not because of your efforts to pull down somebody, right? To degrade somebody. So let us not do that. Of course, criticism is okay. Reasonable criticism is fine. But if you're progressing at the cost of somebody to pull down somebody, I think that is not the best way to become a good professional, a labor law profession. And the fourth one, friends, right? Fourth one is also very important, right? We can progress, we can become a good professional, right? Provided we recognize our limitations. So therefore, acknowledgement of limitations, of failure, or pitfalls is, I think, is very, very important to really overcome these limitations, right? The moment we acknowledge our limitations, we can grow, right? We can become good professionals. So therefore, acknowledge your limitations. And nobody is perfect, right? Nobody is expected to know each and everything under the sun. Like labor law. Labor law deals with several dimensions. Like, see, the starting point of labor law is contract of employment, right? And fundamentals of contract of employment are well established, right? There's, you see, the labor jurisprudence or that judicial trends recognizing important dimensions of a contract of employment or contract of service. Therefore, we must know the fundamentals of the subject with an integrated approach, right? It should not be only confined to only this section, that provision, this provision, right? It goes beyond that. So therefore, to become a good professional, we must know basics, number one. Number two, we need to have integrated approach, integrated approach to understand several dimensions of labor law. So therefore, it is, I think, not so easy to teach labor law with that integrated approach. And the last one, friends, I believe that clinical legal education component in case of labor law, I think, is very, very important in today's context, right? If we are going to just summarize literature, that bare acts or maybe judgments or maybe analyzing some articles written by some scholars, right? Now, it is very easy for the students and I think the stakeholders of labor law to just go through the literature. So what is expected from the teacher? A teacher is expected to go beyond the literature, right? Number one, he has to examine the literature. Number two, he has to understand the application parts, right? That application of these fundamentals. So therefore, that applied labor law, I think, is very, very important. The students must be in a position to apply fundamentals, to identify based on relevant facts whether a person is a worker or not. Then who is a worker? And then application of fundamentals of worker to a given individual and draw some conclusion. This is with respect to maintainability of claims, right? If a person is a worker according to IRC or the person is an employee, right? We must know that application component of several labor laws, right? So labor law, is governed by contract of employment, right? Workers are covered, employees are covered, but India has not accepted universal application of labor law. So therefore, it becomes very, very important to understand the dimensions of labor law. And applied labor law, I think, is very important. If you don't teach students that clinical legal education component, like you give them some hypothetical proposition, like a person is engaged to perform this assignment or that assignment, maybe skilled work or unskilled work. Don't provide details of skilled work, unskilled work. Provide the details of some kind of functions performed with the person, like the plantation or maybe clerical work, accountancy work, or maybe office work, dealing with the some policing data, etc., etc. Thereafter, the person is removed from service without following principles of natural justice. Whether that person is a workman or worker for the purpose of IRC, right? Or whether the person can approach a labor tribunal. So in order to really understand the maintainability, whether person can approach Industrial Disputes Act, that was, I think, before IRC, that Industrial Relations Code 2020. Now, Industrial Disputes Act 1947 has been superseded by IRC 2020. So we have new dimensions of industrial relations law, right? So therefore, you have to really illustrate the concept, who is a workman. So therefore, I think it is very, very pertinent to understand labor law in practice, right? Labor law in theory is very different from labor law in practice. We know that. So therefore, a teacher is also expected to know what is happening in practice. Or this labor law fundamentals are being practiced by several stakeholders, like the principal employer, or maybe the contractor, or maybe the labor enforcement agencies when it comes to labor dispute, individual dispute, or industrial dispute, as the case may be. So this is, I think, very, very important part of any professional. Number one, recognizing ethical values, ethical dimensions. I think this is very, very important. So therefore, in addition to this IQ, we must recognize EQ as one of the important components of the profession. This is also applicable to labor law teachers, right? Labor law professionals or stakeholders. Number two, professional competency. Professional competency or excellence in case of labor law, I think, profession. That is very, very important. Devotion and commitment, right? So these are, I think, the important values which are required to be imbibed by all the stakeholders of labor law governance. I'm one of the students, I think, of labor law governance, right? And we have been dealing with several issues regarding protection of interest of workers. We have conducted several empirical studies to really recognize, to find out. So therefore, diagnosis of the problem is very important. We know theory, equality, right? Equal remuneration law, right? We have done some empirical research on that. So therefore, we know that equal remuneration in practice, especially in case of construction industry, especially in case of unorganized sector, is a real problem. There are other issues also when it comes to equality, like equal opportunity for employment, etc., etc. So I'm going to discuss several paradigms of labor law in practice, labor law in operations, right? So I think with the given mandate, I'm really grateful to Professor Goda for providing me this opportunity to interact with the stakeholders. The labor law, I think we have a labor law commissioner from Andaman and Nicobar, I think, a wonderful person, right? And we have several teachers practicing labor law. So let us have some discussion and interaction to know more and more about labor law, right? So therefore, if you have any question, any clarification at any point of time, you are most welcome to raise your hand, right? So let us have some, I think, some systematic discussion, right? So, friends, I am going to discuss number one, labor jurisprudence. So, without discussing labor jurisprudence, you can't really examine existing labor law. You can't really examine the pitfalls of existing labor law. So, therefore, I strongly believe in three fundamentals of subject analysis, right? When you examine strike or maybe lockout or maybe see contract of employment or layoff or anything, so try to focus on three fundamentals. Number one, I call it three W's, right? Three W's, and first W is related to labor law jurisprudence, right? What was the law? What was the status of contract of employment during ancient time, right? Nature, color, and character of contract of employment during ancient time, right? And I'm going to discuss that that Kotilas Arsastra, recognizing workers' rights, and other codes providing the details, the deplorable condition or pathetic working conditions of workers during ancient time, then modern, that medieval time, modern time, and what is happening in case of LPG, right? LPG, liberalization, privatization, globalization, right? Recognition of workers' interests in case of fundamental rights of workers regarding minimum wage, payment of wage, right to strike, and then collective bargaining. There are several fundamental, I think, rights which are recognized by ILO core convention. There are 10 core conventions recognizing several dimensions of labor laws, right? So I'm going to discuss that again, labor jurisprudence, that character, color, and nature of contract of employment during ancient time. Thereafter, what is the status of labor law, right? I'm going to just analyze the fundamentals of contract of employment or contract of service. Then what are the limitations of four labor codes? Of course, we have not accepted universal application of labor laws. Most of the labor laws are applicable to industrial establishments according to number of workers employed, like EPF scheme, 20 or more. Factory scheme, when now number of workers requirement has been increased from 10 to 20, 20 to 40, etc., etc. Right, employment standing order scheme, again increasing that threshold limit from 100 workmen to 300 workers, etc., etc. So in most of the cases, you would find there is a number of workers requirement. Number two, there is another restriction, that wage limit or monthly wage drawn by your pay to a worker, like EPF scheme, 15,000 rupees, ESI 21, wage 24, right? So you have, I think, some kind of restriction. So therefore, and we have not accepted universal application of labor law except in case of this minimum wage scheme, right? But I believe there are certain issues regarding that also when it comes to employee for the purpose of minimum wage scheme, employee for the purpose of payment of wage scheme or payment of bonus scheme, or etc., etc., right? So we have just combined labor laws. We have not integrated labor codes, right? That is, I think, one of the limitations of existing labor codes, right? So let us have some discussion on labor jurisprudence to really recognize, analyze, see that the real character of contract of employment during ancient time, medieval time, modern time, and after 1991, right? Okay, and then I'm going to just illustrate the real character of a labor law. Fine. Then I think I have to upload that PPT. Just a minute, sir. Yeah. Right. Can you see this PPT?
Yes, sir. Yes, sir.
Sir, can you ask somebody to really upload it on that the platform, because this is in addition to a platform. In case the PPT is visible on your platform, I think that would be great help.
Sir, it's visible, sir. It's available.
Right, it is visible, sir, but we have that additional screen. It is not
Yes,
part of the main screen.
Correct.
Right. And let us, I think your IT team can really support me, help me to make it visible on the main screen. The PPT, I think, should be
Rakesh, sir?
visible on the.
So for us, it is visible on the main screen.
Yes,
I don't know, for
sir.
you, sir, it
Sir,
is
For us,
visible,
it is
but
visible in the main screen only.
So you just make it PPT presentation, sir.
That
no,
is,
that is PPT
Slide-
only, ma'am.
slide
You are
showing,
using
slide.
you are
Yes.
using Zoom, right? Zoom platform, isn't
Yes,
it?
sir. Yes, sir.
There are certain, I think, the keys, or you have some features where this the PPT will be part of the main screen. Now, see, for me, I'm using this additional screen where PPT is visible on different screen, and then I think Zoom platform is visible on different screen.
Now, for us, it is visible on main screen.
Main
Yeah,
screen.
right. But
Yes, sir.
it is not the case for me, sir.
Oh, it's not in your case, sir. So,
Right.
can you
go to
see
slideshow,
the
please,
in
sir.
a toolbar, sir? Share icon is there.
Ma'am, I've shared it, right?
Okay.
This
Yeah, you just share it, sir.
okay, I've shared it now. This
Okay.
is visible,
Yes,
Yes,
sir.
but
Yes,
this
sir.
is not.
Yes, sir. It is
This is
visible.
not integrated with the main screen, sir. I can see that the college, right? If the Vivekananda college, that is the main screen for me. That PPT is not visible on the main screen of Zoom platform. So
But
can we
it's
just
visible
integrate that
on-
PPT into this main?
Rakesh, sir, are you there?
Yes, ma'am.
Rakesh,
Yes,
sir.
ma'am.
ನೋಡಿ
ಮ್ಯಾಮ್
ಅದು
ನೀವು ಶೇರ್
slide show.
ಸ್ಕ್ರೀನ್ ಅಲ್ಲಿ
ಹಾ
ಈಗ PPT ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ ಇದೆಯಾ ಲ್ಯಾಪ್ಟಾಪ್ ಅಲ್ಲಿ?
ಇಲ್ಲ ಅವರಲ್ಲಿದೆ. ಅವ್ರೇನ್ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ ಈಗ 2 ಸ್ಕ್ರೀನ್ ಬಂದಿದೆ ಅಲ್ಲ, ಸೊ ಅವ್ರಿಗೆ ಪೂರ್ತಿ ಇದು ಸ್ಕ್ರೀನು ಅವ್ರಿಗೆ ಕಾಣಿಸ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. ಸ್ಲೈಡ್ ಶೋ ಮಾಡ್ಬೇಕಾ, ಏನ್ ಮಾಡ್ಬೇಕು?
Can it be
ಇಲ್ಲ,
done?
sir, just touch on that screen, sir, which you want.
ಹಾ
See
Sir, you
that
touch on the
Screen,
slide,
you just
whichever
touch
you
on the
want, sir.
slide.
Right, it is now. See, you can see that. Right, this is additional
Yes.
screen for me. Okay, fine, no problem.
Yes.
I'll manage that because we had that problem yesterday, day for yesterday. Right, where the program, you know, that there's a program on labor law is being organized by Aniru Rachi, right? So they could manage it, but now in this particular case, I think there's some problem to integrate that PPT into main screen. Screen, no problem. Okay, fine. Because we are with limited time, let us have some discussion. Okay, friends. Now see that introduction to labor law. So we have to really explain the utility of labor law, nature and scope of labor law, because again, it is based on perception. And I tell you one important, I think, a fact regarding that misconception, right? Now, time and again, we refer to Bangalore water supply judgment, right? I hope you remember the dimensions of Bangalore water supply judgment. That Bangalore Water Supply and Sewerage Board versus A. Rajappa, AIR 1978, Supreme Court 5487 judgment, right? And the judgment is very important from the perspective of the triple test, dominance related test, and sovereign and non-sovereign functions, right? And time and again, we refer to Justice that V.R. Krishna here, right? That V.R. Krishna here is considered as the originator of the triple test. Is it so? There's so much of literature is available in the public domain. So can we consider Justice V.R. Krishna here as the propounder or creator of the triple test without really understanding labor jurisprudence? So therefore, labor jurisprudence, I think, is very, very important a part of labor law. So if you want to really examine that applied concept of labor law or clinical legal education, our theory must be very sound. We must know each and everything about that labor jurisprudence. Right. So can we consider Honorable Justice the V.R. Krishna here as the creator or originator of this triple test? I hope you know the details of triple test: systematic activity, cooperation between employer and employee, right? And then for the production of goods and distribution of goods and supply, etc., etc. I think it is known to everybody. There are relevant facts, there are irrelevant facts. And the functional aspect of that industrial establishment shall be taken into consideration for determining the status. There are certain exclusions also. And same has been recognized by Section 2P of IRC, where in concept of industry has been defined. There are certain inclusion and exclusion. So my question is, do you think the judgment, Bangalore Supply, and specifically Honorable Justice V.R. Krishna here, can be considered as the originator or creator of this triple test? Again, labor jurisprudence. Very important. So much of literature is available. And I tell you, one senior professor was of the opinion, yes, this is the status. Triple test was originated by Justice Krishna Iyer in that judgment. Is it so? Let me see. Somebody. Some inputs. Say yes or no. Okay, fine. Because yeah. So friends, if you trace out the labor jurisprudence regarding industry, so we must know Section 4 of Australian, right, Conciliation and Arbitration Act 1904. Section 4 contains 3 parts, but we have borrowed only 2 parts, right? And this is also directly related to the judgment of 1908. I'm referring to Australian High Court judgment of Jambuna Coal Mines, 1908. Thereafter, 1919, that municipal share, the Federated Municipal Shire, Municipal and Shire right corporation versus, I think that the Melbourne Corporation, 1919. Thereafter, 1929, Federated State School Teachers Association versus State of Victoria, 1929. Right? So if you really examine industry, and according to this, I think this the judgments, industry means a cooperation between employer and employee for production and distribution of goods and services. So that was the beginning of that concept of triple test. It was examined by several judgments in 1953, that judgment of Banerjee Mukherjee, right? Then Justice P.B. Gajendra Gadkar in that judgment of State of Bombay versus Hospital Mazdoor Sabha. In that judgment, the triple test was discussed, was codified by Justice P.B. Gajendra Gadkar. That was in 1960. There is another judgment of 1960, that is City of Corporation of Nagpur. Again, 3 judges. Justice Subba Rao, Justice P.B. Gajendra Gadkar, and maybe I think Justice Das. Right? Now see, the judgment of 1978 has just reiterated, recapitulated the triple test and dominant nature test from these judgments. Right? So therefore, it becomes very, very important to know labor jurisprudence. Don't be misled by some kind of analysis by A person or B person or C person. So therefore, a labor law scholar is required to examine the literature from original document. Don't simply go by that some kind of footnotes or some kind of reference or quotations by A person or B person, right? So therefore, friends, labor law jurisprudence, I think, is very important. Let us see that character and color of contract of employment, because the starting point of labor law is contract of employment, right? A person is covered in contract of employment, may be covered under labor law in our case, because we are not accepted universal application of labor law, except in case of minimum wage scheme, right? Yeah. So this is, I think, the mandate of labor law is contract of employment. So therefore, you have to integrate other disciplines also. Constitution law is the mother of law. Labor law, you have that, I think, see part 3, part 4, 7 schedule, right? Labor law is part of concurrent list. This is, I think, known to everybody. So therefore, labor law in theory, again, is different from labor and practice. Therefore, clinical legal education, I think that the requirement in case of labor law is very, very important. So I'm going to discuss some hypothetical proposition in case of labor law. So when you teach labor law, kindly have a multidisciplinary approach. It should not be confined to only sections, right? It deals with philosophical dimensions of labor law. The basis of labor law is recognition of all the stakeholders, equality, right? Workers should be treated at par with the counterpart, that is the master, right? So that is industrial democracy in case of collective bargaining. In case of, I think, payment of bonus, there are several schemes, participation of workers in management of industrial establishments. That is also recognizing equal status of, I think, workers or association of workers in that case. So therefore, social justice component is important. The labor economics important, right? And then constitutional paradigms. So in addition to understand the labor legal dimensions, we must understand other dimensions of labor law, right? So this is, I think, very important to have a better understanding. Now, friends, now see the character of labor law, right? Character of labor law before 17th century. That see that workers were traded in open market like commodities, right? They were traded in open market like commodities, and the worker was considered the property of the master, the owner. That was the relationship between the stakeholders. I'm talking about the character of contract of employment before 17th century. And this is also evident from, see the literature available, the Code of Hammurabi, right? Now see the code number 199, right? If that employee was injured, the compensation was paid to the owner, the master. No compensation was paid to the employee or slave, right? Now see the compensation was paid to the master, and this disobedience was considered as a crime. Physical punishment was available, and this is also evident from the pictures. I'll show you some pictures collected from the internet. Right now, see slavery in ancient Rome. It was not confined to only one particular civilization. They see our Indus civilization also, right? I'm talking about the prevailing caste system in India, right? Where that workers were classified on the basis of caste, not according to skills, right? I'm talking about Manu Smriti and other components recognizing workers on the basis of caste, right? So I'm discussing Manu Smriti only for the purpose of classification of workers on the basis of caste system. Now see, this is a picture that is, I think, very evident from this particular picture. The workers were traded in open market, right? And highest, that the bidder was, I think, was given the possession of the person, right? The workers were treated as commodities. And this is the second slide. See the kind of treatment, no protection, physical punishment for breach of contract of employment, right? So again, that I think you know all the details, right? Fine. Now, Arthashastra, I think, is a very important document recognizing a workers' rights regarding the wage, fair wage, right, protection of workers, etc., etc. So you can read this Arthashastra in order to have a very good understanding of accountability of ruler in order to protect our workers organization, right? So therefore, this is, I think, this is a wonderful piece of public administration recognizing workers' interest, right? Now see thereafter how the workers, I think, that rights were recognized. Formation of trade union was considered a crime at some point of time. I'm talking about that the specific legislation of 1351, right, where that association, right, formation of association of workers was considered crime. The Combination Act 1799, then 1800, etc., etc. So there were some legislations. Workers were not allowed to form associations. Now, in case of India, Factories Act 1881, right, restricting working conditions, working hours, and we know the contribution of that Haymarket massacre. Workers were killed. They were demanding the better terms and conditions of employment. So we celebrate International Labor Day on 1st May to respect these the workers' sentiments, right? To recognize the sacrifice of workers, right? Now thereafter, see that recognition of workers' rights in one or the other form. Fine. So see, the labor law or contract of employment or terms and conditions of employment have been devised, have been demanded by workers. So therefore, you have labor law recognizing several rights of workers, right? So I think between that 17th and 19th century, some specific legislations recognizing workers that entitlement. So during that period, what was the nature of contract of employment? Master and servant with partial bonded, I think, labor approach, right? Now, during 1950, ILO, Trade Unions Act was enacted, employees compensation was enacted, and I think this Royal Commission on Labor is a wonderful, I think, report available. You should read this. And thereafter, enactment of ESI, then Part 3 of Constitution, Part 4 of Constitution. And friends, this was the golden era, 1951 to 1991, right? where workers were recognized, workers were allowed to participate. The scheme was created in the form of Article 43 capital A of our Constitution. Judiciary was also proactive, right? This was a period of first generation of labor law reforms. So I consider the period before 1991 as a period of first generation of labor reforms. And first generation of labor reforms were demanded by workers, supported by the state, supported by the judiciary, right? Where workers were recognized, labor law was considered part of social welfare legislation. So therefore, workers' rights were liberally interpreted. But see what is happening after 1991. I'm talking about second generation of labor reforms, where labor law has been considered or was considered as a kind of impediment in production market relationship, right? So therefore, that second generation of labor reforms have been demanded by employer or MNCs or industrial establishments, right? Because we consider a labor law as an impediment in production relationship. That is, I think, incorrect approach, because sustainable development requires development of all the parties, not the development of only that one stakeholder. You relax labor law in order to reduce cost of production by exploiting workers. Can it be considered a real case of sustainable development in case of labor law, etc., etc.? I think it is for the stakeholders to really look into several dimensions of second generation of labor reforms. Of course, we have implemented 4 labor codes. The 4 labor codes are not complete, not effective. There are certain issues regarding that also. We'll discuss that, right? So thereafter, after 1991, things are very different, right? You know that how the market forces are regulating contract of employment. There's too much of contractualization of workforce. Workers are engaged for a particular period in order to deny them long-term benefits like gratuity, like other benefits. Now, of course, we have come out with that fixed term tenure, right? But who is going to employ workers for that period, right? So there, you know that the breaks, right? And I call it unfair labor practices adopted by several stakeholders in order to deny certain protections to workers, right? That too much of contractualization. Now we have new dimensions of contract of employment, right? That is not considered a traditional form of contract of employment. Before 1991, contract of employment was considered part of traditional contract of employment. Now you have new dimensions of contract of employment, like gig workers, platform workers, where workers are engaged for a particular assignment, right? And workers are designated as partners, right? Partners, or maybe they are called by some different names. But friends, if you apply contract of employment, gig workers are worker, platform workers are workers, right? They are covered under labor law, because labor law is regulated by 4 fundamentals of labor law, right? And in case of liberalization, I tell you what is happening in case of this retrenchment. I hope you remember all the details of retrenchment. You know, retrenchment, section 25F under Industrial Disputes Act. Now we have chapter, I think, chapter 9, the 10 and 11 under IRC. We have borrowed similar provisions. What was the rule regarding retrenchment? Retrenchment is generally a removal of surplus labor. That is, I think, the basic concept. Retrenchment means removal of a person by employer other than by a disciplinary action. There are certain exceptions also. Now we have 5 exceptions. Before that, we had 4 exceptions, right? Now, section 25F, there was the mandatory requirement. If the mandatory requirement like prior notice, justification, etc., was not followed, what was the legal status? Right? Person was considered to be part of that establishment, right? There was automatic reinstatement of person along with all the benefits. Now, friends, what is happening after 1991? The court is worried about, number one, the nature of employment, right? In case of temporary workers, part-time workers, or maybe that contractual workers, there is no scope of reinstatement. That is first breach of that, I think, that fundamental. Number 2, the court is also, I've seen Supreme Court, several judgments. We have examined 50 judgments delivered at Supreme Court after 1991 and before 1991. We have just compared that. I think article has been published by Labor Law, Labor Law Journal, right? Now, what is happening? The Supreme Court has started taking into consideration the financial implications, right? Financial implications of restatement. What will happen to employer in case restatement along with back wages is ordered? So I think there is a deviation, and there's another. I think part of that employment injury. Again, before 1991, if a driver right became disabled, driver not in a position to drive the vehicle again, he was considered to be a case of 100% disablement. Now what is happening after 1991, right? Now the Supreme Court has started taking into consideration that rehabilitation measures. So of course, if a driver is not in a position to drive the vehicle, he can operate computers, typewriter, etc., etc. So therefore, I think Supreme Court is confused between inability to work and inability for work. And this is because of, again, reforms, right? That is, I think, one of the problems of judicial interpretation by the judiciary, right? So this is, I think, happening. Now, friends, we know contract of employment is very important. So when we teach contract of employment, we must illustrate contract of employment, right? Contract of employment hovers around 4 important parameters. Number 1, the person must have been employed by the employer. There can't be any employer without employee. That is, I think, right. So therefore, there were 3 stakeholders of labor law: employee or workers association. Number 1. Number 2, employer or employers association. Number 3, the state. The state was considered to be the regulator, controller before 1991. Now the state after 1991 has become facilitator of this protection relationship between employer and employee. It has become facilitator. Now we have 4th stakeholder, that is contractor, right? That is the middleman, and middleman, I think, is involved in exploitation of workers. So in most of the cases, right, that you see services, essential services are outsourced. Housekeeping, security, even teachers are also, I think, employed on contractual basis. They are not paid regular benefits at par with permanent employees. This is happening. So there's too much of contractualization, right? So number 1 is that the person must have been employed by the employer, right? Number 2, person must have been paid by the employer. Number 3, person must have been subject to supervision and control by the employer. Number 4, person must have been, I think, dismissed or removed. Some action must have been taken by the employer against the worker or employee, as the case may be. If these conditions are fulfilled, a person can be considered as a worker or employee or workman, as the case may be, right? And there was no requirement written agreement in our case, right, before implementation of OSH. Now OSH requires a written agreement, that is a written appointment letter, because this is very important from the perspective of burden of proof. It is the duty of that worker or employee to prove his status, right? This is regarding maintainability of the claims. Otherwise, that application is not maintainable. If person is not a worker or employee for the purpose of specific labor statute, right? Employee for the purpose of industrial relations code is different from employee under minimum wage or maybe that EPF scheme or ASI scheme, etc., etc. So therefore, it is very, very specific. Who is a worker for the purpose of IRC? That is defined by IRC. That I think 2ZR has defined the term worker, right? So worker means a person employed in an industry to perform skilled, unskilled work, etc., etc., etc. Fine, right? So this is very important in this particular case, right? So therefore, a worker, I think, is very, very specific. So therefore, written agreement. It is very difficult to establish a status in case somebody is employed through contractor, a series of contractor. OSH has mandated that there is a requirement of a written appointment letter, right? So burden of proof has to be exercised by, or the burden of proof lies on the worker. He has to prove his existence, right, by way of identity card, by way of appointment letter, by way of duty slip, pay slip, right, or maybe job slip, etc., etc. But what happens in practice? These documents are always in the possession of employer. Very difficult to prove that the existence of that relationship. Therefore, I think this is the real problem in our case. So we must really illustrate this concept of employment with the help of, I think, given factions, given that fact and circumstances, right? Make some hypothetical proposition, some kind of fiction, in order to explain students the content of employment, the status of the person, whether the person is a worker or not, how to determine status of the person, whether the person is a worker or not, whether that establishment is an industry or not, right? Whether there exists an industrial dispute between the parties or not. So I think this is the best way to really illustrate the concept of basic concept of industrial relations, basic concepts of social security or wage or OSH, labor welfare, etc., right? So therefore, what is important in case of contract of employment, right? The functional aspect, not the designation. Like partner, if somebody is designated partner, kindly examine functions performed by the person. If somebody is considered as or designated as manager, managing director, or apprentice, so what is expected by a labor law professional? The labor law professional is required to examine functions performed by the person in order to determine his or her status for the application of labor law, right? So therefore, designation of person is very, very, I think, not so relevant. It is the contribution, the functions performed by the person is important. And see, peace rated worker is also a worker. Why do you want to really I think differentiate or separate that worker? Like gig worker is not a worker, platform worker is not a worker, right? Because the person is paid according to the piece delivered or some specific performance of particular act, right? So therefore, whenever you examine contract of employment, you can relate it to any law, social security, OSH, labor welfare, wage, etc. So therefore, kindly examine, illustrate, explain it to students contract of employment and difference between contract of employment and contract for employment. Therefore, we must examine, I think, these landmark judgments, right? And I'll show you that important judgments. This Chintaman Rao, that is 1958 judgment. Three concepts: employer, employee, and contract of employment. Contract of employment deals with terms and conditions of employment, right? And again, time constraint, friends. Now, this is the landmark judgment, right? Landmark judgment, Short versus J and W Henderson Limited. Lord Thankerden and friends, these fundamentals of contract of employment have been reiterated, examined, accepted by Supreme Court in more than 50 judgments. Like Dharangdara Chemical Work, Shelling, I think Taylor's, Silver Taylor's, Hossein, by then you have that, I think, several judgments, including that judgment of that 2014, that is the judgment recognizing the status of Balwant Rai Saluja versus Air India Limited. There are several judgments reiterating the status of contract labor and the contract of employment, right? I think that, again, the distinction between contract of employment and contract for service, right? Again, there are chemical works, the control part, right? That the control and supervision is the most important component of determining state of the person, right? Of course, there are certain issues regarding controlling professionals, so therefore we have developed integrational tests or organizational tests, right, to determine status of the person. Again, that I think Jago versus Union of India, December, several judgments. So designation is not important. That judgment from US, I think, is reflecting on the same issue. Designation is not important. Whether person is designated as an apprentice, apprentices are not covered. Apprentice who is regulated by apprentices in 1961 is not covered under labor law. But an apprentice who is governed by other schemes like Employment Standing Order Scheme would be covered under IRC, but not under other laws, right? I think this is very, very important to really understand. And why do you require labor law? We know labor law is very important, right? Labor law is required to protect workers. Labor law is required to provide, I think, several benefits to worker. Labor law is required to recognize social justice, right? Social justice through sharing of profits, right? The industrial democracy and the recognition of trade union for the purpose of collective bargaining, So we require labor law to protect workers. Otherwise, I tell you, labor law does not exist in practice. You know what is happening to inspection policy. And I tell you a real life example. We have conducted some empirical research on construction workers, right? In order to find out whether female workers were getting equal wage at par with male workers, right? This was regarding Equal Remuneration Act, right? And see, friends, based on that empirical data, it is evident that female workers engaged in construction industry are considered as subordinate to male workers, right? They are not provided the same wage at par with male workers. It happens because of, I think, that working capacity also, right? This is one of the I think the issue, the problems where employers are reluctant to engage female workers. Female workers are engaged only for specific work, right? And male worker is expected to perform anything. I'm talking about similar work, same work performed by male and female workers, right? So because of that, I think that the capacity, physical capacity, working capacity, female workers are hardly engaged in case of construction industry. They're engaged only for a specific work, like maybe for supplying material, bricks, etc., right? This is again the real problem. And the second issue regarding minimum wage, right? See, we consider minimum wage as part of Article 23, fundamental right. We refer to that the judgment of Justice P.N. Bhagwati, that's Asiad Games judgment, right? If an employer, is not in a position to pay minimum wage, it shall be considered as begar. Begar means without pay, right? And in case employer does not have financial resources to continue trade and business, he has no right to continue trade and business, right? So therefore, right to minimum wage was considered part of Article 23. But friends, what is happening? What is happening in practice? Just find out from the security staff engaged, right? Or engaged by various educational institutions, housekeeping staff engaged by various stakeholders, or contractual labor engaged by stakeholders, right? And I tell you again a real life example. The real problem is there is no protection that is available under Minimum Wage Act, right? The moment some complaint is filed against an employer, that worker may be thrown out of employment or very next day or the same time. No protection is available. Some amount of protection is available under that Industrial Disputes Act 1947. Now, I think that Industrial Relations Code, that 2020, Section 90 and 91, right? That terms and conditions cannot be changed and every person can approach the designated forum, right? So I tell you again, several reported instances in a particular case. See that students team visited one particular website, one particular work site, right? Workers were working in stone industry. I'm talking about state of Rajasthan, right? They visited that place. They found that several workers, including minor workers, were working, right? They inquired from them that payment, whether they were getting that notified wage, that minimum wage notified by the government of Rajasthan at that point of time, right? And then it was discovered by the team that the supervisor was maintaining two different registers. One register for that statutory minimum wage, second register for actual payment paid to these people. Then we wanted to file that PIL on behalf of these workers. When we approached these workers, they were so reluctant to file any complaint, right? And see, according to them, see, something is better than nothing. A very next day, the moment complaint is filed, what is going to happen? It is known to everybody. I think you can foresee that kind of implication, consequences of filing complaint against employer. So where's the labor law in practice? So therefore, you have to really understand the real character of labor law. So illustrate, I think, labor law basic concept with the help of real life instances. And then I think a teacher is expected to know the functions performed by labor commissioners, functions performed by adjudicatory agencies. They must know that the real character of labor law from the perspective of trade union leaders, right? So therefore, I think that holistic approach is very important to teach labor law. It should not be confined to only that theoretical dimensions of labor law, right? Now see the friends, the regulation, etc., etc. Fine. Labor law was considered part of controlling mechanism before 1991. right? Regulator. Now state has become facilitator, right? This is my perception. You may agree, may not agree with that kind of approach, right? Now labor law, you know that how things are different. In case of OSH code, we talk about OSH code. There are 10 core conventions, and we have included 2 core conventions which are related to social OSH, right? The convention number 155 and convention number 187. These conventions are very, very important for the purpose of health and safety. But what is happening in case of construction industry, I have seen it. I have seen the functioning of BOC, Building and Under Construction Workers Welfare Board. All things are happening. So therefore, I'm in a position to really examine the functional aspect of these schemes. Of course, theory is very good. There is no dearth of labor legislations in India. But the real problem is labor law enforcement. So therefore, teachers are also expected to examine labor law enforcement, labor law and why that the efficacy of labor law enforcement, right? And number 2, that we time and again we refer to enforcement. There's a problem enforcement. As to why then enforcement is not so effective, it happens because of several parameters. I have written some paper on that. Paper has been published by EPW, right? So lack of quality enforcement, and it happens because of number 1. It happens because of that inspection policy. We have done away with that surprise inspection, right? Is online inspection, right? You know that certain see the checklists are prepared, details are submitted. Policy. Number 2, availability of manpower. I have also examined, see that working strength of that staff, that the directorate of factories taking care of enforcement of health and safety measures. I have also examined working strength of these people. There's a wide gap between sanction strength and working strength of these enforcement and enforcement agencies. And number 2, skills. Too much of generalization of skills possessed by these, I think, stakeholders. We require specialized inspectors, right? We require specialized, I think, labor commissioners, right? The generalization is not going to work. Number 2, trade unions are also not so strong. I think because of that, workers are not in a position to really bargain for better terms and conditions. So there are several issues because of that labor law enforcement has been so weak, right? So we have to really acknowledge that. So I think we require labor law to recognize social security dimensions, economical dimensions, and to really promote international instruments. India has entered into social security agreements to take care of that duplication of social security contributions. Right, we have recognized several UN as well as ILO's convention. Right now, friends, these are, I think, the sources, right? And these are, I think, ILO's core conventions. We have ratified 6 out of 10 core conventions. We have not ratified 87 and 98 and then 155, 187. But of course, we have ratified this core convention number 29, forced labor, abolition of forced, yeah, right, 105, then minimum age 138, then 182, I think, 182, child labor, 100 and 111 dealing with the equal remuneration and equal opportunity for employment. But we have not ratified 4 conventions, including 155 and 187. And friends, again, see, ratification of some convention is not a guarantee of effective implementation of the scheme, right? Of course, by making, I think, a specific legislation, municipal law, we recognize certain rights. But again, enforcement is a real problem. And enforcement of labor laws in case of unorganized sector is a real problem. Whether there is a wide gap between demand and supply. Huge supply, very low demand. So there is every possibility of exploitation of our workers. If you want to really examine the real character of labor law, kindly conduct some research to know more and more about agriculture sector, then construction sector, other activities in directly or indirectly related to unorganized sector. Of course, organized sector is well protected. But what about that 80 to 85% of the workforce engaged in unorganized sector? I think this is the area where we have to really introspect. We have to really promote the interest of unorganized sector. So therefore, I always recommend to have a separate code on unorganized sector workers, to codify their rights, to specify their rights, like maybe minimum wage, some kind of social security, medical treatment, right? It should not be on the basis of contributory scheme, like when a worker is required to contribute, employer is also required to contribute, right? Now we have several schemes recognizing workers' entitlement, but I think again, number one, awareness. Number two, training. Number three, espoused by trade unions, the causes of workers employed in unorganized sector. There are several issues, right? Now, of course, we have to formalize our workforce. That is, I think, one of the important parts of recognizing rights or terms and conditions of workers. But it does not happen because of, I think, several regions. And we are using AI tools and techniques. Mechanization is happening. Of course, we can't really avoid that mechanization. But we should adopt the technology which I think supports the involvement of workforce. Of course, skill development is very, very important part of the development, or maybe a use of AI tools and techniques. In several countries, European Union, China, before there are some schemes, some provisions. It is that I think the duty of the employer to justify the displacement or employment that would be generated because of involvement of some technology, right? That is, I think, very important. And then they have rehabilitation schemes. But in our case, we have come out with some I think skill development fund, etc., where some additional remuneration is paid, but real skill development is not happening. So therefore, skill development is very important. So when we teach labor law, you should also focus on that, the transition from unskilled workforce to skilled workforce or semi-skilled workforce, as the case may be. So this is, I think, one of the important parameters of that bargaining capacity. This is again very important from the perspective of labor, that economical dimensions, right? That cost benefit analysis. Fine. So this is, I think, again, a very important part of labor law. We know that labor law is a part of a concurrent list, right? And then part 3, part 4, we have several dimensions of labor law, right? Part 3, recognizing several rights: right to form association, right to minimum wage, right, again, that again, total prohibition on engagement of child labor. We have several, I think, Article 32, PIL, then I think the labor tribunals under Article 323, capital B. Fine. So I think these are the entitlements of workers, recognizing, I think, entitlements of stakeholders. Now see, classification of labor laws according to subject matter, according to protections, group protection, individual protection, and power to legislate and power to enforce. So most of the labor legislations are covered under that third category, right? Third category means appropriate government. Appropriate government, that is central government and state government, right? So they have the power to administer and legislate. So four codes have been implemented and legislated by central government, but there are several schemes which are enforced by appropriate government, like industrialization scheme, right? In case of a state where workers are covered under that state category, appropriate government in case of central government employees, appropriate government in case of state government employees, or maybe that private employees engaged in particular establishment in a particular state. So therefore, the territory jurisdiction becomes very important to determine status of appropriate government. So that is very important. Like employees compensation commissioner is appointed by state government, that registrar of trade unions appointed by state government, right? Generally, powers are delegated to labor commissioners, right? So this is, I think, very important part of labor enforcement. So I'm not going to discuss this classification because of time constraint, right? Now I'm going to discuss the special labor laws, right? Or labor laws have not been subsumed by 4 labor codes, not included, right? Like bonded labor, manual scavenger, the prohibition child labor, domestic workers, option commercial establishment, etc., right? These have not been included. Now see again classification, fine. Now 4 labor codes, code on wage, taking care of 4 schemes. That wage scheme, minimum wage scheme, bonus payment of bonus scheme, equal remuneration, right? We are just, I think, combine these schemes. That integration is, I think, missing by and large in most of the cases, right? Now, if you see all these schemes, IR code, we have just combined 3 schemes. Number 1, Trade Unions Act. Number 2, Industrial Disputes Act. Number 3, Employment Standing Orders Act, right? We have different applications. The industry for the purpose of, I think, trade union scheme is different. Worker for trade union scheme is very different from Industrial Disputes Act and Employment Standing Order scheme, right? We have just consolidated, combined 3 statutes into 1 statute. There is no integration, right? That is the real problem of labor law. Integration has not taken place in case of social security. Some schemes have been consolidated, right? Combined. Instead of having 10 schemes, we have only 1 code, social security. The same is the case of OSH code, I think the 2020. That's more than, I think, 10 schemes have been combined. Factory scheme, migration, then plantation, and then I think contract labor scheme, VOCW, etc. Several schemes have been combined. Same is the case of the wage. We already discussed that, right? And then I think code on wage, again, different schemes, different wage limit, number of workers requirement, social security. Social security is actually based on 2 important fundamentals: social security assistance and social security insurance, right? Insurance means EPF, where contribution is paid, right? ESI, where contribution 3.25 by employer, 0.75 by worker or employee. In case of EPF, 12%, and by both the parties, and 10% in specific cases, right? So this is, I think, the area where we can do some research to really integrate the functional aspect of these schemes. So why to have so many schemes? Why can't we have only 1 scheme in case of social security? Single scheme covering workers, single contribution, single administrative agency, single adjudicatory agency, instead of having that insurance court or maybe that appellate authority under that Industrial Disputes Act, or maybe that IRC, right? So let us have only single scheme, single window system. Why to really, I think, duplicate, or I think multiclate, or multiple agencies are involved in some kind of adjudication, right? So I think, I'm done, friends. Let us have some, I think, discussion. Otherwise, it becomes, I think, one-way dialogue, right? So let us have some discussion. We can have some discussion, question, answers, right? Yeah, I think I am done with that, because, again, time constraint, friends. And there's some issues regarding my field studies. I have conducted several field studies, directly or indirectly related to that functional aspect of labor law. So therefore, a teacher is expected to really examine clinical legal education components. That is, I think, the need of the hour. If a teacher is going to just repeat provisions, I think teacher is not contributing. Teacher is expected to really contribute to the discussion. Otherwise, what the purpose of engaging teachers? Students can really, I think, find out the literature. There's so much of literature that is available in the public domain. Bare acts are available, judgments are available, articles are available. So a teacher is expected to go beyond that. That is, I think, the real reiteration. So the teacher is really required to illustrate concepts, right? Identify, I think, the concepts like a worker, industry, employee for employees, that Compensation Act, worker for the purpose of ESI or employee, as the case may be, right? So there are a lot of confusion regarding worker, employee, or maybe by different names, right? That is, I think, the real issue. So what is expected by teachers? Integration. I'm again reiterating, recapitulating certain fundamentals of labor law teaching, right? Number 1, a sound understanding of fundamentals. Number 2, integrated understanding of fundamentals. Number 3, that multidisciplinary approach is very, very important. Number 4, clinical legal education. I think that inclusion or integration is important. So therefore, applied labor law. They should not be confined to only that theory, concept, provision, etc., etc. Don't examine the scheme from the perspective of scheme. That section 1, 2, 3, 4, 5. Have integrated approach. Section may be related to section 40. Section 40 may be related to section 12. Right. So therefore, understand basic concepts. Like when I teach industrial dispute scheme, right, I discuss the mandate. That is, I think, very important. The mandate, the objectives, then the basic concepts like, appropriate government. Number 2, industry, because IRC is applicable to an industry, several dimensions of industry, industrial establishment. Then number 3 is that worker or workman, worker and employee for the purpose of IRC. Who is a worker? Who is an employee? And then industrial dispute, right? Difference between industrial dispute and individual dispute, right? Okay, friends, let us have some questions, and I'm going to stop this sharing now.
Thank you, sir, for your valuable insight about applied labor law education, policy and research.
Just a minute.
Participants, now the session is
Just a
open for the
minute.
discussion. You can ask any questions or queries to the research persons.
Right, I think there are some questions.
Yes,
Let
sir.
them ask the questions, because I'm not going to use the chat box. Yeah.
Vijay,
Yes,
sir,
kindly permit them to raise their questions.
you read
Yeah.
from the chat box.
Yes, yes. Sir, there are some questions in the chat box.
Aha.
What is the main problem faced by the central and or state government in implementing agricultural laborers welfare laws?
Yeah. See, we have to really understand the coverage of agriculture workers, right? What are the scheme under which the workers engaged in agriculture sector or construction sector are covered, right? Well, see, number one problem is demand and supply, right? There is a huge supply, very low demand. So that kind of arrangement has really affected the bargaining capacity. Number two is awareness. Workers, are not aware of their entitlements. Number 3, trade unions have very little, I think, very low role to play. I've seen it. Trade unions have not been so effective in protecting workers, that rights in case of unorganized sector, that agriculture, the sector, or maybe construction sector, right? So, of course, labor laws are applicable when it comes to see that employees compensation scheme or minimum wages scheme, right? But when it comes to see that a PPF scheme or maybe ESI scheme or other schemes where you go by the concept of industry or factory, right? Factory is, I think, very narrow term. This is part of industry. So factory means manufacturing process. That is, I think, very, very important component of factory, right? So therefore, we need to really specify sensitization. Training is important. Skill development is important. Now, I agree with you that the workers engaged in unorganized sectors have not been protected, right? Because of low quality of enforcement, sensitization, and bargaining capacity, and not supported by several stakeholders, right? Yeah, please. Next.
Yes, sir. Veena madam has some questions. Do you think that new labor codes help the labor sector than that of earlier enactments?
See, if you compare the coverage part, see, we can compare that earliest legislations. Like if you compare Industrial Disputes Act with IRC scheme, or you compare that see that EPF Act or maybe the CLRA with that OSH code, right? Let us talk about only IRC or Industrial Disputes that Act 1947, right? Now you see the concept of industry, right? Concept of industry and the interpretation by judiciary, it was very broad, right? And then the certain exclusion regarding sovereign, non-sovereign function. But now we will see section 2 P of IRC. They have excluded sovereign functions performed by specific institutions, right? Number 2, they have also excluded some specific functions, all functions performed by some specific, departments like space, right? Atomic energy, defense, production, etc., etc. Now that appropriate government has the discretion to exclude any establishment, right? So I think if you go by that analysis and analogy, I think IRC has excluded workers. Now see that again, layoff, retrenchment, etc., etc. Under ID Act is what it was confined to only, I think, 100 workmen. Now that exclusion has been, I think, extended. Threshold limit has been increased to, I think, 300 workmen. Same is the case of Employment Standing Orders Act. Employment Standing Orders Act was applicable to a particular industrial establishment employing more than 100 workmen. But now this IRC has increased the threshold limit from 100 to 300. So now you can really, I think, draw some logical conclusion from the facts, right? So see, in most of the cases like CLRA, right, that registration was required in case of CLRA by a particular labor contractor employing 20 or more contract labor or establishment also. Now that threshold limit has been increased to 50. Same is the case of factory scheme, right? So if you see that application threshold, I think most of the workforce has been excluded from the ambit of labor law. That is, I think, what the real problem, right? Otherwise, labor law is, yeah, of course, you need to appreciate minimum wage scheme also. Minimum wage scheme where that universal application has been extended, right? Yeah, major differences between, I think, that Trade Unions Act and IR Code, I think, known to everybody, right? That collective bargaining component has been increased. Collective bargaining component has been included in that trade union scheme, right? Registration process is same, and you see that the privileges or immunities which are available to registered trade union are the same. Section says that 17, 18, 19 under Trade Unions Act and 16, 17 and 18 under IRC, similar provisions, similar right? Yeah.
Sir, Jaykumar has a question. Who are the gig workers? What are the legal impacts of gig workers under labor laws?
See, the real problem is, see, who is a worker, right? So you must know who is a worker. Worker may be gig worker, right? A worker is engaged to provide goods and services. Now, a gig worker is engaged by some company, right? Person is engaged to provide some services, to deliver goods. Fine. Person is paid some incentive, maybe commission or etc. etc. Person is subject to some supervision and control. So therefore, I think if you examine that Uber versus Aslam, the judgment of February 21, UK Supreme Court judgment, right? A wonderful judgment, right? Uber, see, all workers engaged by Ola or Uber or by any platform agency are subject to some kind of, I think, some kind of artificial tools and techniques. So if you apply 4 fundamentals, the person is employed by employer. Person is paid by the employer. Now the payment is not important, whether salary is paid or maybe that wage is paid or incentives are paid. It includes pecuniary as well as non-pecuniary benefits. Where commission is paid, that is also not so relevant. Now the third one is the person is subject to supervision and control. Right? Gig workers are supervised and controlled by artificial intelligence, right? Adopted by the company, the platform, the agency, and they can be removed in case there is a violation or services are not satisfactory. So by applying the contract of employment, according to my understanding and drawing some analogy from, I think, the several judgments and several policies in the European Union, and I think the China also, right? They are workers. But again, see the policy adopted by the state, right? They are covered and they are not covered under traditional contract of employment, but they are covered under modern contract of employment. That is very narrow approach, very narrow interpretation. And according to me, I think they are covered under all the codes, right? All the codes, provided they fulfill the requirements of, I think, the codes, right? Of course, according to Social Security Code, they are covered. Then the fund has been created, etc., etc. That is, I think, very narrow approach of that interpretation of contract of employment or contract of service. according to my analysis, if you apply fundamentals of contract of employment and the judicial interpretation analysis by that judgment, I think they are workers, right? You can apply it to platform workers, gig workers, or any worker. Okay, fine. Yeah,
Sir,
anything else?
Next question is 100 days guarantee scheme workers will come or not?
Oh, good question. See, do you think somebody who is engaged under Manrega scheme can be considered a worker? Like some, that unemployment allowance is paid in case the person engaged under Manrega scheme is not paid, not provided that work. So, what is the status of a person who is engaged under Manrega scheme? Number one, somebody who is engaged under that Anganwadi scheme, right? So, how would you really decide that? Let me see. See that Manrega scheme. Now this is known by different name nowadays. So right. So don't bother about that name, etc., etc. Whether a person, 100 days work or more than that, the days work is provided to a person, right, with respect to household or particular family. In case work is not provided by the agency, then unemployment allowance is paid. Is there certain grievances? There is a scheme, panchayat, block development officer, etc., etc. Scheme is funded by central government as well as state government, right? Suppose there is a person, right? Person has not been provided with some kind of work as required by the policy, and person has not been paid unemployment allowance. Whether that person can approach a labor tribunal, whether that person can approach payment of wages authority or minimum wages authority, right? So how are we going to really determine the status? So first of all, we have to determine the state of the person, whether the person is a worker for the purpose of labor law or not. Yeah, let me see. Who is the person? Let me see. Just ask that person whether a person engaged in Manrega can be considered the worker by applying 4 parameters. Right? Yeah.
Yes, sir. Dr. Sumitra, madam, has some questions. Can these labor codes help the workforce in multinational companies where they are compelled to work beyond their working hours on a regular basis?
I see. The first, this is Manrega part. A person who is engaged under Manrega is not a worker. That's right. The grievances of such people are regulated by Manrega, right? But in case of Anganwadi, there is a different scheme. Just apply that, I think, fundamentals of contract of employment to a Manrega worker, as well as the worker who is engaged under the Anganwadi the scheme, right? So it is very easy to really understand. Now, coming back to the question of that MNC, can you repeat the question?
Yes, sir.
MNCs, right?
Yes, sir. Can this
working hour?
Yes, sir. Can these codes help the workforce in multinational companies where they are compelled to work beyond their working hours on a regular basis?
See, now you know that that limitations of labor law. A person who is considered a worker or employee is covered under labor law, right? So then, in case they are covered under that particular the law, maybe Factories Act, maybe any other act, or Absorption Commercial Establishments Act, then there's a well-defined working hour, working conditions, overtime, etc., right? And workers cannot be forced to work beyond that, but it does not happen in practice, right? Because it is a matter of, again, bargaining capacity to really bargain for better terms and conditions, right? So in case there's a working hour 8 day, right, 8 hours working hour with that lunch break, half an hour, etc., or 48 hours in a week. In case that period exceeds 48 hours, then worker is entitled to, overtime wage, right? So this is, I think, again, in case a worker is not paid that overtime wage, then he can approach that appropriate agency, payment of wage authority, right? But again, the coverage is important. Maintainability is very important. If person is not covered under that the scheme, Factories Act, and payment payment of wage scheme or minimum wage scheme, then he has to approach a civil court to ventilate his grievances, right? Or in case person is covered under Absorption Commercial Establishment Act, then I think that designated agency is required to adjudicate or ventilate that the grievances. And in case the person is covered under IRC, there is a definite scheme. And the person is not a worker, then, civil court jurisdiction is always available. Otherwise, jurisdiction of civil court in most of the subject matters related to labor law has been barred, expressly barred. Now you have some provision in the Industrial Relations Code barring the jurisdiction of a civil court. A civil court cannot take cognizance of the industrial dispute related subject matter, right? So it is, I think it depends on the factual circumstances of each case. Yeah.
Yes, sir. Sir, another question is, how can we make applied labor law more relatable for LLB students who don't have industry exposures? Are there any classroom exercise, mood problems, or intensive recommended we introduce early?
See, CRE, courtroom exercise, right? So formulate some hypothesis. Suppose you want to discuss worker, right? Whether person is a worker or not, number one. Number two, whether that establishment is an industry or not. Number three, whether there exists an initial dispute or not, right? So therefore, discuss theory, right? Theory, then make it, I think, very, very easy to all the stakeholders to understand fundamentals of worker, industry, industrial dispute. Then come out with some hypothetical proposition, like suppose there is an industrial establishment A. A has employed some 67 workers, 50, right? 50 workers through contractor, 5 apprentices under Apprentice Act 1961, or maybe some different workforce. So then workers have certain demands regarding increase of wage, or maybe declaration of holiday, or they declare a strike, right? Then proper notice. Strike is not possible, right? Legal strike is not possible under that IRC in certain cases. Prior notice is always required, right? So therefore, they come out with some hypothetical proposition. Ask student whether person is a worker or not by applying fundamentals, right? The starting point of IRC is industry. If particular establishment is not an industry, IRC will not be applicable. So make some hypothetical proposition or discuss some reported judgments, right? Examine factual matrix, modify factual matrix. So I formulate some hypothetical proposition and involve 2 different parties, one from employer's perspective, second from worker's perspective, right? And then we generate some discussion how to decide the dispute, right? Number one, whether there exists a dispute, whether person is a worker or not, right? The subject matter of dispute, the jurisdiction of a labor tribunal to take cognizance of the dispute, and the dispute decision on merit. This is the way, I think, to generate discussion and to apply, I think, fundamentals of labor law. I think the best way. Otherwise, just show them some videos regarding working conditions, right? And ask, I see experts like labor commissioners to deliver some lecture, right? The trade unions leaders to deliver some lecture, right? Or maybe that presiding officer of labor tribunal to deliver some specific lecture. Or you can just take them to maybe to some work site, right? Or then involve them in some kind of field studies to know more and more about contractual labor, the pay, wages, right? Domestic workers. So I think this is very important. Otherwise, if you are going to just discuss theory, nobody is, I think, would like to participate in that discussion. So therefore, you have to really relate labor law to the real life instances, routine instances, right? So I think this is the best way. You might face problem in the beginning, but the moment you really come out with hypothetical proposition, real life instances, reported instances, I think you will be in a position to really deal with that. But you must be very thorough about the subject. You must be very thorough about landmark judgments. Explain, support. See, duty of a teacher is to facilitate students. Spoon feeding is not desirable, not required. The teacher is a mentor, facilitator, guide, and friend, right? So therefore, support them, facilitate them. Spoon feeding is not relevant. Don't be part of that appeasing policy or maybe that populist approach, right? Okay, fine.
Thank you, sir. Thank you, sir.
Okay, I think, yeah, it is. Oh
Yes.
my God.
May I now
7:30.
request Srimati Vinuta DN, Assistant Professor, Vivekananda College of Law, Bangalore, to propose vote of thanks.
Good evening to all. This is my
See,
proud.
just a minute. See, friends, you know the limitations of online lectures, online discussions, right? You have now 75 or 80 participants. I don't know how many participants are really attending this, or they have just logged in only for the purpose of certificate or otherwise. That is, I think, the real problem of all these online, I think, interaction discussions. So therefore, that the offline, right? Of course, you require to take care of logistic, etc., etc. But again, despite all these odds, there should be some participation, right? Some kind of discussion is important. Otherwise, it becomes one-sided affair. Okay, let us conclude this. Thank you. Thank you very much, friends. All
Good
right,
evening
I
to all.
think, yeah.
This is my proud privilege to propose the vote of thanks on the occasion of 7 days faculty development program, which is organized by the Vivekananda College of Law, Janata Education Societies. At the outset, I express my sincere thanks to our respected resource person, Dr. Jeet Singh Man, Professor, National Law University, Delhi, for sparing his valuable time and enriching us with their insightful and thought provoking sessions. I extend my sincere thanks to our respected principal, sir, Professor KB Kempegowda, sir, for his encouragement and guidance in organizing this FDP program. My heartfelt thanks to faculty development program coordinators, teaching members, participants for their active participation and cooperation throughout this program. Thank you, one and all.
Thank
Dear
you.
Okay,
particip-
friends.
Yes, sir. Dear
Professor, thank you
participants,
very much.
please,
Yes.
we
Vijay.
please inform you that the session schedule tomorrow will be delivered by Professor Shiv Prasad sir, Registrar Ramaya School of Law, who will be sharing his views on Code on Wages 2019, the challenges of codification of wages laws in India. Looking forward to see you all tomorrow at the same time. Thank you. Thank you very much.
Okay, friends. Thank you. Thank you very much, sir. Take care.
Thank you,
Bye-bye. Good
Professor,
night. Thank you. Thank you,
for
sir.
the
Bye-bye.
insightful lecture.
Thank
Thank you. Thanks all the participants. Good evening.
May I end the session, sir?
Yes, yes, ma'am. Please.